Mr. Johnson, are you ready with Mr. Beckman's case?
Yes.
Go on the record in versus Beckman.
Come on up to the podium, Mr.
This is
Beckman.
an AG case.
It is an AG case. I think.
Ms. Courtright, are you appearing in the People versus Beckman case?
Yes.
Okay, we'll go on the record in People versus Beckman. This is file number 255378. If I could have counsel put your appearances on, please.
Police report right on behalf of the Attorney General's office.
Thank you, Your Honor. Jason Thompson on behalf of defendant Jeremiah Beckman. Your Honor, I'm appearing on this case for the first time. Mr. Garrett, we had Mr. Vernon on very briefly, but he identified a conflict within his office. And so he had to come off very quickly, and we apologize for all that, but I am on the case now. I attempted to reach Ms. Brenner, who was what I had down as counsel of record on the matter. Haven't been able to speak to anyone from the AG's office. Mr. Beckman did make a payment today of over $1,000. I also understand he has $1,000 on deposit with Mr. Garamuthi, his former attorney's account. I confirmed that with him verbally last week. Mr. Garamuthi was supposed to be here with us. I guess he's running late to confirm that. And I was intending to ask that be turned over to friend of the court and applied to his arrears. I understand there's a plea offer. If Mr. Beckman can get his arrears under $20,000, and that'll get him down to the payment today, and the $1,000 that Mr. Garamuthi would get him down to $20,490. So Mr. Beckman indicates in about a week or two he can get that balance under $20,000, which is what I understand to be the condition to receive the plea offer, although I haven't again spoken to the AG directly. Thank you.
All right, Ms. Courtright, can you speak to that in terms of the plea offer?
Yes, it was a plea offer of if the defendant got the arrearages below 20,000, then he could, I believe, enter into a delayed sentence plea to pay current support. And then there was another amount that he had to get it below by the time the 11 months was over to get an attempt after the delayed sentence. And I do see back in March, there was about 4,500 received, and that was from his bond. And in May so far, and I'm just talking about towards the arrearage, $1,110 was paid on the arrearage. So right now his arrearage is $22,490. So it sounds like the two amounts, if they're $1,000 each, he'd still be about 500 short of that.
So, Mr. Thompson, are you asking the court to set this over?
I am, Your Honor. Between me just appearing on the case and how close Mr. Beckman is, I'm hopeful if we had a June or a July date, be able to enter that plea counsel is described.
Ms. Courtright, do the people have any objection to a 30 or 60 day adjournment?
Can we do 30 days? It
Yes.
sounds to me like he should be able to get that money very quickly.
Okay. All right. The court will set this for a status conference plea hearing in about 30 days.
And Your Honor, I assume there's no objection if I submit a proposed order that the money in Mr. Garamuthi's trust account be paid in front of the court and applied to his arrears.
Mr. Beckman, do you have any objection to that?
No, no. I could have the other $500 paid by the end of the week, so
Okay.
that's not a problem with that. It's just all the money that I've been paying is like having a hard time getting everything going here, so.
Sure.
If he did make that
Right.
$1,000, attempted to try to make that payment when he was here back in March.
Okay.
And so front of the court, my understanding was wouldn't receive it, so it went to Robbie. Robbie held it till today.
Yeah, and I understand it would be helpful in the front of the court to have it denominated, whether it goes to arrearages or not, so that's our request.
Judge,
Yes.
the way the payments are received by the front of the court, every month, no matter what is paid, for him, the first 490 is going to go towards his current support. So on June 1st, if he paid $1,000, the first 490 would go toward his current, and the balance would go towards his arrearage. Now, he's already paid his current support for May, so any new money that he pays now in May will go towards his arrearage. By federal statute, that's how they have to allocate the money.
Okay. Ms. Lee, was there anything you wanted to add?
She just stated what I was gonna tell the court as well.
Ms. Corright, I don't know, you probably can't see, but we do have a friend of the court.
Oh, perfect.
caseworker. So.
Perfect. That's great.
Okay, all right, so we'll proceed then with the status conference plea hearing as we've discussed. Mr. Beckman will send you notice of the date and time of that hearing. Just make sure that you stay in touch with Mr. Johnson prior to that. Okay?
What I'll let council know is that Ms. Brenner has been on a leave, but she returns back to work on Thursday of this week.
Okay,
he'll
so
be on
she'll
the
be,
week too.
all right, thank you, Ms. Covert.
You're welcome.
Okay, that's all for today. Thank you.
All right, thank you.
People versus Natalie Bublitz. This is case number 25539. Sorry. Thompson, is that your file?
It is.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Natalie Bublitz. Your Honor, we got two things up for today. As far as the status conference, Ms. Bublitz intended to enter a plea. I also understand and received the court signed an order revoking her bond. Ms. Bublitz is aware of that. Would ask if the court would consider, allowing her to remain out until her sentencing. We are aware both those things are up today, both the status conference and the
What is the plea offer, Ms. Coker?
Count 2, possession of methamphetamine as a second or subsequent. Count 3, child abuse 4th degree. Count 4, added tampering with evidence, which is 750.483 A6A, dismiss the HAB 2 and dismiss PWID. That's been reduced already. Mr. Thompson has it. I
It
believe.
has. I'm sorry, I just got a bunch of new things over the weekend. So, court will give you a moment. I can track that down.
While we're doing that, Ms. Coke, what's your position regarding the violation?
Your Honor, I believe her bond was violated. She has to be processed on that. In this case, she had contact with the child with the wrong supervisor. We went above and beyond to try to get her some supervised parenting time, and it's 11 o'clock at night and she's running around with this baby and Mr. Lovely and meth in the car. The meth was in the driver's side door. She has 2 prior felonies and 3 prior misdemeanors, and we've just gone round and round with Ms. Bublitz. I don't think it's appropriate that the court cancel her warrant status. I think she deserves to go to jail today, especially given that there was also meth in the car. We charged Mr. Lovely with that meth. Thank you.
Ms. Bublitz, given the nature of the charges here and the nature of the violation, which involved the child, and based on the allegations that methamphetamine also tested positive for fentanyl, which is a deadly substance for an adult, you don't even have to ingest it to harm you. And so I have serious concerns for public safety, your own safety, and the safety of the people that you're with. So I do think that's correct. The court has already revoked your bond. I'm not going to reinstate it. So I'm going to deny that request. Did you still want to go forward with the plea agreement?
Yes, I do.
If I may approach, Your Honor, we do have a written plea agreement. I think that'll help orient the court because there are a few different charges.
And Ms. Coke, what is the maximum possible penalty for the added count 4?
Your Honor, I'm sorry, I'm gonna pull that up from my. It is a 4-year and or $5,000 consecutive sentence may be imposed for other convictions. It's a public order class F felony.
Okay, so Ms. Boblitz, I'm gonna go through with you the charges that are part of the plea agreement and the maximum possible penalties to make sure that you understand that. The first charge is the possession of methamphetamine, and is that with or without the second?
With a second.
So,
And Your Honor, that's the second controlled substance violation as compared to second habitual.
all right, so that means that possession of methamphetamine charge carries with it a maximum possible penalty of up to 20 years. Do you understand that?
Yes, Your Honor.
Count 3, which is the child abuse 4th degree, that's a misdemeanor that carries with it a maximum penalty of up to 1 year in jail or up to 5 years on probation. Do you understand that?
Yes, Your Honor.
And then this added charge of tampering with evidence carries with it, and that's as a second habitual.
No,
Without it.
correct.
That carries with it a maximum possible penalty of up to 4 years and or a $5,000 fine.
Yes, Your Honor.
With all of those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
To go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if they're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you. Right to testify at a trial yourself if you want it. You understand that you have all of those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty to each of these charges because you are actually guilty?
Yes, Your Honor.
Okay, so this happened back on November 24th of 2024, is that correct?
Yes.
Date were you here in Crawford County?
Yes.
Did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes, Your Honor.
You have the legal right to have any amount of it at that time.
No, Your Honor.
And when you had that methamphetamine, did you try to hide that in your child's clothing?
Yes, Your Honor.
Child was a minor at that time?
Yes, Your Honor.
Yes. I'm not sure the tampering charge, I'm not sure.
I believe it's the same in terms of the concealment of the evidence. Your Honor.
Okay, and was it your intent in placing that methamphetamine where you did to try to hide that intent being discovered?
Yes, Your Honor.
With that, Ms. Pope, do you agree there's a factual basis?
I would like to ask one additional question. Ms. Bubitz, you handed the child with the methamphetamines or tried to hand the child off to somebody else to conceal it?
Yes.
No further questions.
And as to the factual basis,
I believe the factual basis is adequate, Your Honor.
Ms. Pope, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Spoke, are the people satisfied that the court has complied with statute and court will undertake this plea?
Yes, Your Honor.
Yes, Your Honor.
So let's, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. Set this matter for a sentencing hearing. Will be meeting with the probation department for a pre-sentence report. And then you'll have a chance to talk to Mr. Thompson about that prior to that hearing.
Yes, Your Honor.
And then I'm going to have you go with the court officer.
Okay, so they'll put it in your property. Did she carry that?
Thompson, you have a here for the court on this Bradley's case.
Yes, and Mr. Hill, but the victim is here, Mr. Hill.
And Miss Bradley is here, so when it's the scheduled time, we'll be ready to go. I believe Mr. Gurmith is talking to him in the hallway right now.
Yeah. Okay.
No issue on restitution. No issue on restitution. No issues on the restitution. No. Yep, so we'll stipulate the restitution.
Mr. Hill, you can come right in there. We'll go on record in People versus Thomas Hill, file number 245287, 25536, 5392. One of those files is this sentencing hearing on a probation violation. The other two files are sentencing hearings. Mr. Hill, did you have an adequate opportunity to go through these reports with Mr. Germer being talking about them?
I went through the report by myself and the questions that I had, I asked him about, so.
You need more time to talk to him before we proceed.
I just went back there, my couple concerns, I got the papers here.
There were some issues with credit, and we'll address that on the record. But my calculations are different than Mr. McFarland's than Mr. Hill, so. And I did review the restitution that I just received with Mr. Hill, and we would not be objecting to that restitution.
I just want to make sure that you don't need more time to talk to them before we go forward.
No, everything should be okay.
So Mr. Germer, what are the corrections?
So Judge, Mr. Hill, based on his calculations of the dates, he indicates he was arrested on the 5th instead of the 6th. And based on when his bond was revoked, instead of 96 days of jail, he would have 99 days of credit.
So I'm looking at 14 days of credit between February 5th and February 18th.
So in file 5386 FH, 70 days, I think that's accurate there.
Okay.
However, he was arrested then on 2/5 instead of 2/6. So 2/5
Oh, you're talking on the probation.
on the probation violations.
45287.
Correct.
So the violation arrest, you're indicating happened on February 5th.
So he would have been violated on the 5th and picked up the OWI charge on the 5th. Yes.
Judge, I've been able to look at my case notes and everything. I guess I'm not fully understanding what we're trying to look at correcting. Just on the probation violation file?
Sounds like it.
That's the probation violation file. And I'm a little confused as to what Mr. Hill's trying to explain. I'll have him explain that.
I caught this new charge on the fifth one.
So my understanding is that in file 5386, that would be, his arrest date would be 2/5.
Mhm.
He was released on 2/8 and then was back to 12.
On these two charges.
Okay. So we need, and I do see that, he was arrested on February 5th. So,
Judge, I don't have any issue with that on as far as this violation arrest on 2/5 instead of 2/6. I think this happened right at around midnight.
It was.
I know it was because I was there. It was around midnight. It was,
actually 2/4 going into 2/5.
I'm fine with the 2/5 date. That would give him one extra day. It would be 105 on his violation.
okay, does that sound right?
That would be correct. then, Judge.
Okay, so we'll make that correction. Any other corrections?
And then I have in 5392 FH restitution, which is 296.59, and we're stipulating the rest of my charges.
Any other additions, deletions, or corrections to the body of the report?
So the only other correction I would have then, judges, that would change the credit then on 5386 FH. Because he has 70 days, bond was then revoked since he was incarcerated on 2/12. Does that make sense, Judge?
No, because on 5386, he's getting credit from the 5th through the 18th, so that's 14 days. of credit.
I'm getting somehow extra because on my paperwork here, it says that I'm only getting 70 days
Mhm.
instead of the whole time that I've been here. Because I got released on the 8th and then I come back on the 12th. And
So I would-
I've been here ever since the 12th of February.
So from the 12th to now, I would have that at 99 days.
But his bond was not revoked until 3/24, according to what I have. That's where it's getting mixed up. He may have been sitting in jail,
I thought,
but he was out on bond on that file.
It was on 3/20.
On 3/6, Your Honor, my notes say that bond was posted by a third party. Plea cutoff is in 30 days. Bond is revoked as of the day of incarceration.
Oh,
Sounds like we did that on the record.
okay, so then he would be entitled to that credit. Going back to the date of incarceration, what you're saying is 2/8.
2/12.
it was the 5th, but I was only here for a couple days.
So he posted bond on the 8th and then 2/12 was arrested on the 2 new files.
Yes.
Okay. So, oh, and I see, all right, yeah. So 2/12 through 3/24.
Correct. Which would make it 99 days, but today's, if we count today.
Do not count today.
No,
Okay, then it'll be 98 days.
all right,
On the 5386.
5386, 98 days credit.
Thank you.
For the record, the 5392. State of 2/12. Any other corrections, Mr. Gerber?
No, sir.
Are there any challenges to the scoring of the guidelines?
No.
Or do people have any additions, deletions, or corrections?
No, Your Honor, but we do have a victim that wishes to speak.
Do you have any challenges to scoring the guidelines?
No.
Hearing, Mr. Gerber, if you, Mr. Hill, can be seated, and I'm just hearing if you want, did you want to make a statement today? Ma'am, your, for the record, your name's Erica Gearing.
Yes,
Can you spell your last name? for me?
Geering.
Thank you. What is it that you would like to say?
I don't have anything written down. I didn't even plan on coming today. But I'm here for me, my son, and everybody that's been affected by our relationship. This has gone on for years. I uprooted my life to come up here to start fresh. That didn't happen. I have to say though, since Mr. Hill's been gone in jail, me and my son are finally starting to live the way we've been wanting to. We're making great memories with amazing people. And I just want the courts to consider just everything, just appropriate time for everybody involved. And you know, I want happiness for Mr. Hill. I want everybody to be able to just get through things and start living the way we want and be happy and
Scope, anything on behalf of the people for allocation?
The court's very familiar with this file. I think the facts stated in the PSI adequately put forth what happened. I understand that the circumstances in which this happened in were pretty tragic to Mr. Hill, but his behavior was a completely inappropriate response. His guidelines are pretty high because of the mistakes he's made in his past and the history that he's built himself, which shows at 45, he's got 7 misdemeanors and 2 felonies. I would ask the court to follow the sentence recommendation. Thank you.
Mr. Gerber.
Thank you, Ariane. Mr. Hill agrees that the recommendation is within reason. He would like to get some help with treatment, and when he does that, he would ask the court to give him day-for-day credit. If he successfully completes that treatment, he's apologetic to his significant other, and I know he hasn't had that opportunity to communicate that. Even though we modified the no contact order, there is a personal protection order that is still in place. So I don't know if that is something on the record we could ask, or that needs to be modified or left in place.
We had a hearing on that.
Okay, that was, okay. I didn't know that. And again, Mr. Hill was apologetic regarding what brought him before the court. You know, that his daughter passed away due to a genetic condition, which certainly led him to then consume alcohol and have the police, we call them subsequent offenses with domestic violence, and the R and R. And certainly Mr. Hill is not proud of what brought him here, but I think there is some issues that brought him here. He recognizes that, and has indicated he wants to go back to work, he wants to be able to remain sober and put his family back together. There should be some happiness within his family. Mr. Hill recognizes that as well, but ultimately it's on him to bring some of the happiness back to the circle. So I would ask for the
Thank you. Mr. Hill, anything you wanted to say today?
Yeah, I apologize for everything. My drinking definitely got way out of control. I know it did. I've quit for 8 years in the past. Stupidly, I picked it back up. I was a heavy beer drinker in the past. I was able to quit on my own with a little help of AA. This time, moved on to liquor and was drinking very, very, very heavily. And with my daughter passing, I lost it. No excuse, but I am sorry for what I did. I know it's a mistake. I gotta get sober again. That's my biggest downfall right now. I've got a lot clearer head being in here for a little over 3 months. But I do want to do some kind of treatment. Of course, it's easy in here. Don't have access to it. But I think with treatment, I can keep myself sober.
All right, I read through the report, so I'm familiar with the circumstances here. I was already familiar with you based on the case from last year, so I already kind of had that background information. We've had a number of different hearings regarding the personal protection order, which also gave me some additional background, not only into the circumstances here, but I think some things that have gone on prior to this. So I feel like based on all that information, I have a good overview of your circumstances for the purposes of determining an appropriate sentence here. I think it's completely understandable to react the way you did to the death of a child. That's a difficult thing for anybody to handle, even under the best of circumstances. Add in issues with substances, there's way too great of a temptation to turn to that to deal with hardships like the death of a child, as opposed to dealing with it in a more responsible way. And in doing that, you not only get yourself in trouble, but you further victimized everybody else around you who were themselves going through just as tough of a time as you were. And that's a really selfish thing to do. I think that based on what I've heard, there were problems even before that in terms of your use of substances and the way that you treated particular Miss Gearing, that relates to the domestic violence charge that being sentenced for here. So I think this has been an ongoing thing that was just made exponentially worse by a really bad development. All of that being said, I think that there is still an opportunity here for rehabilitation, and the sentence here is going to allow for that possibility. But you need to understand that your guidelines here are prison guidelines. So to the extent that you violate your probation, once you get to that point, and you serve your upfront jail time, any violations of probation, I think in this code, if you're found guilty of violating the probation, it's going to be a really good argument for the court sending you to prison later on if you don't comply. So there's some punishment up front, some jail time up front here for your actions. There's the opportunity to get some treatment, to work on your issues. And I hope that that's the way that it goes, but if it doesn't, then you've got really no way to avoid prison time after that. So I think altogether that addresses all of the types of things that the court tries to address through sentencing. So in terms of file number 255386, that's the operating while intoxicated offense. The court is going to place you on probation for a period of 36 months. The court is going to adopt as the terms and conditions of that probation all the terms and conditions that are listed in the report. The court is going to order that you serve 12 months in the Crawford County Jail. On that file, you do have credit for 98 days served. The court will allow you to be released to inpatient treatment after the first 9 months upon written confirmation to your probation agent that you do have a bed available. If you successfully complete inpatient treatment, then you would get day-for-day credit off the rest of your sentence. If you fail to complete residential treatment, then you would be returned to the jail to finish serving your time, and you would not get any credit for the time you put out at treatment. On that file, the court is going to order $130 crime victims assessment, court costs of $325, attorney fees of $350, $68 state costs, and a $30 per month supervision fee while you're on probation. That's the file number 5392. The court is going to sentence you to 5 months in the Crawford County Jail. On that file, you have credit for 96 days served, $130 crime victims assessment, and $118 state cost. That sentence will be served concurrent with the previous file. In terms of the probation violation, the court is going to discharge you from your probation. Unsuccessfully, the court is going to preserve any outstanding fines and costs. And on that file, the court will sentence you to 105 days in Crawford County Jail with credit for 105 days served. You have the ability to seek an appeal of all of these sentences.
Judge, restitution,
Oh, thank you.
Judge, I would ask or recommend that be added to the OWI file, just because that's the file he's on probation for, to ensure that I can make sure he gets that paid.
Okay, so as to that file, the court will order $296.59. Restitution, that's payable to the Crawford County Clerk. Who is that dispersed?
Oh, Miss Geary.
Okay, be dispersed to Ms. Gary. Mr. Renke, has Mr. Hill acknowledged receipt of his appellate rights?
Yes, Judge, I did. And then go over the paperwork. All 3 months.
You're against the custody this time.
Okay, I have one question. Who can I talk to about trying to find like treatment centers? Would that be Mike or?
I'll do,
Mike will do
we
it.
got time. I'll talk to you.
Thank you.
Talk about the other day.
Thank you.
Okay.
Laptop.
Ms. Gearing, thank you for being here today. I appreciate your statements here.
It'll go to plan, Judge.
That was a lot.
I'll get the- I'll go back.
Come back here this week, right?
So it was on the record. I don't know if there was an order, sorry.
It's fine.
Yes.
If I heard the foul. Trails. Green screen.
Victim of Bradley is joining us remotely. Is that correct?
Via Zoom, yep.
Here, once the hearing actually starts.
Yeah, let's take a short recess. They haven't signed in yet, so I'll give a couple of minutes to sign. Okay, Ms. Coke, it doesn't look like the victim is connected. How do you want to?
We would just ask to proceed. She went back and forth about whether or not she was going to make an impact statement, so she was aware of this.
Okay, we're on the record in People versus Alexis Bradley, file number 245301. And if I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Alexis Bradley.
Record should reflect Ms. Bradley's present here in the courtroom today. This is the date and time set for sentencing. I did receive some notification ahead of time that I should address the court today. But this was set for 2:15. It's now 2:23. No one has signed in on this case. So Ms. Coke, do the people have any objection to the court proceeding?
No, Your Honor.
Ms. Bradley, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections to that?
No.
Are there any challenges to the scoring of the guidelines?
No.
No, Your Honor.
Ms. Coke, do people have any additions, deletions, or corrections or challenges to the scoring?
No, Your Honor.
Anything that you would like to say on behalf of the people for allocation today?
This is a really hard case. It's probably one of the harder ones I've ever worked on because frankly, I'm not completely positive what happened or how it happened. And Miss Bradley has some significant mental health issues herself. Who I think was the leader of this was Kyle Purcell, who the court gave a very significant prison sentence to. You can see in the victim impact statement that the minor child seems to be doing better. The word "all right" was used. She did do some counseling as a result. Alexis Bradley is 25 years old, and I just don't even know how she got herself into this circumstance. I think she was probably in some ways a victim too, but certainly played a role in making a minor child a victim. I think we gave her a plea deal that encompasses all of the factors with her own mental health and the fact that I think she was also the victim of some manipulation. But I do think the recommendation is appropriate. I'd ask the court to follow it. Thank you.
Mr. Thompson, anything on behalf of your client?
Thank you, Your Honor. I think what the prosecutor said is largely factually accurate. It's a very tragic situation that we got here. When the court looks at how we got here, the court will know that Ms. Bradley was a victim when she was a child, that she faces a lot of challenges in life with her mental health diagnoses, that she ended up in a relationship with a gentleman that this court sent to prison for a very long time, appropriately. And that are all the background factors that led to the decisions and the actions that Ms. Bradley made. She did go along with Mr. Purcell in this case. She feels very bad about that. The victim in this case, I just want to address this because there's a comment in the PSI about her not knowing a whole lot about her. They're half sisters that didn't grow up together. They were kind of getting to know each other before this happened, so they didn't grow up as in the same household. I just wanted to say that to explain the comment about her not knowing much about her half sister. She does feel very bad about this. Her sister was victimized by this same person, and that is, an unfortunate perpetuation of that cycle of abuse that Alexis has been in. So she allowed that to happen. She shouldn't have. She understands that she has to try to be the kind of person that protects her two children from having this kind of cycle of abuse permeate through their life. She is getting a lot of help to help prevent that from permeating their life. She is, in any case, receiving a lot of services. She has moved to a new community. She is trying a new start on life. She's receiving mental health treatment. I understand the court is in a very difficult position in this case. I want to respectfully advocate and encourage the court to adopt that HIDA, Homes Youthful Training Act status. I think that allows Ms. Bradley an opportunity to continue to try to better those children's life, to try to avoid that social stigma of being a sex offender, to try to have a chance at things like low-income housing and a lot of jobs and a lot of opportunities. I do think she's a person who's, honestly living on her own, getting some mental health treatment. This is probably the best she's ever had it in her life right now. And I'm hopeful she can take advantage of those opportunities. I know there's a recommendation for jail time. I think sitting where I'm sitting, it's a lot easier. It's that the Homes Youthful Training Act status is by far the most important thing for my client. And I think if the court sees it its discretion, whether to award jail or not, I would just respectfully urge the court to adopt Homes Youthful Training Act status on behalf of Alexis. Thank you.
Thank you. Ms. Bradley, was there anything that you wanted to say? Right, I did have a chance to read through the report. I was already familiar with the circumstance based on the co-defendant in this case. So, I was kind of aware of the underlying reasons for you being here today. I agree with Ms. Coe. This is a very difficult case because I think in a lot of ways, if Mr. Bertel was not involved in this isn't the type of thing that you would have gone out and done on your own or exposed this young lady to on your own. I think I can accept that there was a certain amount of manipulation of the entire circumstance by him to get what he wanted. And because of your own mental health issues, you were in a position to recognize that or to be able to stop it. And so I think that does mitigate your role in this. However, we had some evaluations done. I think you're able to tell what's right and what's wrong and should have known and recognized that what was going on with regard to this girl was not right. And even if you didn't feel like you were in a position to stop it yourself, you could have asked for help and reported it to someone else who would have been in a position. And so in that way, you did, allow this to go on, even though you knew or should have known that it wasn't right. And so I think that deserves a degree of punishment. I think also given your issues and the fact that you may be susceptible to this kind of thing, I think some probation and a term of supervision is also appropriate to make sure that you're staying on the right track and that there is oversight. So I think the recommendation is well crafted. I think it addresses those mitigating factors, but also again provides a degree of punishment for you, which I think is important to press upon you that this isn't something that you can be involved in and just walk away. So the court is going to place you on probation for a period of 36 months. I'm going to adopt as the conditions of your probation all the terms and conditions listed in the report. The court is going to make your probation pursuant to HIDA. That's recommended at your age and with a lack of any prior history. I think it's appropriate to give you that opportunity. The court is, I do also believe that the jail sentence is appropriate as punishment for you to serve as a deterrent. And particularly given that that is going to be a new experience, I think that's necessary to hopefully press upon you that this is not the type of thing that you want to be involved in. The court is going to sentence you to 30 days in Crawford County Jail. Sir. The court is going to order a crime victim's assessment of $130, supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, $68 state costs. Because this is pursuant to HIDA, there is no appellate rights. Ms. Cope, is there anything else that we need to address for the record?
No.
Mr. Costa?
Nothing further for the record.
Mr. Bradley, you are admitted to the custody of the county at this time. That's the first packet.
Sarah, will you text me when Hubbard is up?
Yeah. Yep, and I'll just text your friend or then for Hubbard.
Thank you. Okay.
Can you hear me okay?
Yes, I can. And we're just, Mr. Collin is joining in here, so it's just gonna be a minute. Mr. Collin is still in the process of joining, so if everybody can just stay on hold for just a minute.
It is. Yep.
Hi, on the phone with the last four digits of 3038. Can you tell me your name, please?
Craig Collin.
Okay, Mr. Collin. All right, we'll go on the record in Collin versus Collin. This is file number 2411622. The record should reflect Ms. Collin is present today by video with her counsel, Mr. Vernon. Mr. Collin is present through Zoom by phone. This is set for a status conference in this case today. Mr. Vernon, on behalf of plaintiff, can you tell me as to your side where things are at?
At this point, I think we're probably at an impasse and trial is going to be required. And we've had some conversations, but we've made no progress. There is an upcoming hearing in front of the court on a makeup parenting time issue. At the last hearing, we conceded that makeup parenting time was appropriate and offered multiple different days to make that parenting time up. Mr. Collin objected, so we now have an evidentiary hearing scheduled for that purpose. The division of property, I think Mr. Collin had an unrealistic expectation of what he's entitled to versus what the law says. And I think that a trial is going to be necessary to address those issues.
Okay. Mr. Vernon, how much time do you think we need for a bench trial on just property issues?
Probably a half day. I don't think we'd need a full day.
Okay. Mr. Collin, can you hear me okay?
Yes, Your Honor.
Were you able to hear what Mr. Vernon just said?
Yes, Your Honor.
All right. Do you believe that if I set a half a day aside for taking evidence on how to divide up the assets and debts of the marriage, that would be enough time?
I believe it would be sufficient. I'd have to talk to my attorney about it, but they'll be in contact with them in the near future. But for now, that seems sufficient.
Okay. Have you already hired counsel?
Technically, just for what they call it, where they're just standby. This week I'll be hiring one, and they'll be notifying you guys. They'll be notifying the courts.
Okay, so for that trial, you're planning on having someone appear on your behalf and represent you at that trial?
Yeah, from the Sterling Law Office, Zachary Backlund. And then he'll be representing me. He just couldn't. We didn't get to the agreement finalized today, but yeah, so he'll be present from this point on, basically.
Okay, all right, that's fine. Mr. Vernon, how much time do you think you need to be ready to have that bench trial?
If we're just doing property, we'd be ready in 30 days.
Okay. Mr. Collin, how far out do you want the court to set that hearing?
2 months.
Okay. All
That
right.
way my attorney can get caught up.
Yeah, all right. I think that's reasonable. Mr. Collin is retaining counsel to give Mr. Backlund an opportunity to get up to speed. So the court will set this for a half a day bench trial at about 60 days out. When Mr. Backlund makes an appearance, Mr. Collin, the court will send him notice of that hearing. And,
okay.
And the court, it's my usual practice to require counsel to file trial briefs with proposed division of property 7 days prior to the bench trial. And Mr. Backlund will get notice of that as well once he files his appearance.
Yes.
So the court will send out.
The goal would be to obviously avoid, sorry, Your Honor, the goal is to obviously avoid the bench trial, but if we have to, we will go for it.
Well, yeah, and the lawyers can talk prior to that. If they're able to reach an agreement, then that's great. We can always take that date down.
Okay.
So, Mr. Vernon, any other scheduling dates for your side today?
No new dates. No, I think that's fine.
All right, Mr. Collin, how about for you?
No, Your Honor. Well, I just an update. I have a hearing with the Secretary of State SOS for my driver's license reinstatement on June 6th. But that's not pertaining to this, but I just brought it up. But, so.
Okay. All right, so the court will send out a order reflecting what we've discussed here today. It'll also send out a notice of date and time for that bench trial on property issues, and all parties on this case are free to disconnect. Thank you.
Thank you, Your Honor.
on the record in People versus Ryan Hubbard, file number 991736. If I can have counsel put your appearances on.
Sierra Coke on behalf of the state.
Attorney Troy DeAndre, on behalf of Mr. Ryan Scott Hubbard, sitting to my right, who's the applicant.
Thank you. This is the date and time set for a hearing on Mr. Hubbard's application to set aside a conviction from back in 1999. I did have an opportunity to review the file generally. I had an opportunity to review the petition. It does appear that all the proper notices were given. The AG's office is not contesting that Mr. Hubbard met the technical requirements to have a conviction set aside. Ms. Coke, would you agree with that?
I do.
So what's left for the court to determine then is whether or not Mr. Hubbard's behavior and circumstances since that conviction would warrant having it set aside, and that it would be consistent with public welfare to do so. Mr. Daniel, I usually have counsel take some testimony from their client on those 2 points.
Sure.
We need to do that right at council table.
All right.
Mr. Hubbard, raise your hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Mr. Daniel, you can proceed.
Thank you. Please state your name for the record.
Ryan Hubbard.
Mr. Hubbard, where do you live?
I live in Crawford County, out M18.
You were the applicant here to set aside a conviction from 1999, is that correct?
Yes, sir.
All right. And currently, do you have any criminal charges pending against you?
No, sir.
Other than this conviction on your record, in 1999, have you had any other convictions in your lifetime?
No, I haven't.
Nothing prior to 1999?
No.
Nothing subsequent to 1999?
No.
The conviction in 1999, that was home invasion, second degree, is that correct?
Yes, sir.
All right. And currently, where are you working at?
I am a supervisor at Big Lake Synthetics on 4 Mile. Used to be Georgia Pacific there, but we had sold to Big Lake. And I also have had my own construction business for the last 20 years. So I also continue my construction business and work at Big Lake.
All right. And are you married right now?
Yes, I am.
How long have you been married?
We've been married for 2 years, together for 10 years.
Okay. And you have children?
Yes, I have 4 children.
Okay. What are their ages?
22, 20, 18, and 17.
Okay. And since your conviction in 1999, have you done anything as far as volunteering or working with schools or anything like that?
Yeah, I have. My kids, my older 2 kids entered the youth wrestling program, where I became the head coach for 7 years for the youth wrestling program. And then also the whole Little League, my kids have played baseball and wrestled their whole career from Little League all the way up to high school and finished high school. And I helped coach all Little League all the way through. And then my oldest daughter, I was able to finish her through high school with Lee Wyckoff. He was coaching. So yeah, I applied myself as much as I possibly could in the community. I knew I had something to prove, not only to myself, but the community. So I kept my kids going and everybody else.
All right. And you were familiar with was Under Sheriff Benjamin Lowe?
Yes. Yeah.
And how long have you known him?
I've known Ben my whole life.
All right. And Mr. Lowe, he volunteered to submit a letter on your behalf, is that correct?
Yes, he did.
Okay, and you see the letter?
Yep.
Okay, do you believe all the information contained in that letter is accurate?
Yes, I do.
All right. And you've looked up your record actually on the Michigan State Police website, iChat, is that correct?
Yes, sir.
This conviction doesn't even show up there, is that correct?
That's correct.
Right, but you applied for a CPL license and I guess it was flagged, this conviction flagged your application that resulted in a denial, is that correct?
Yes, sir.
All right, and you're asking the court to set aside this conviction so you can continue on with your and be a productive citizen, is that correct?
Yes, sir.
Your Honor, I don't have any further questions unless the court has any.
Having heard Mr. Hubbard's testimony, Ms. Cope, do people take any position on whether the court should grant this relief?
I believe he has met the statutory requirements, and I would ask the court to grant the relief requested.
All right, thank you. Again, Mr. Hubbard, I did review the petition and the file. I've listened to your testimony here today. It does appear that since this conviction was entered, number one, you haven't had any more contacts with law enforcement, haven't had any additional even charges, let alone convictions during that period of time.
Yes, sir.
From everything that I've been able to review, it appears that but as a law-abiding citizen since that time, with raised a family that have been involved in the community and that have been gainfully employed. I find that those circumstances since that time with warrant having set aside and having you be able to continue engaging in community activities without being prevented from doing so because of the conviction.
Sure.
That at this point it's now 26 years old.
Yes, sir.
That you sounds like largely moved on from. And in light of just a general move on behalf of our society and our community through our legislature, which has made having these types of things set aside easier. I think it's consistent with all of that, to have this set aside. So the court will grant the petition. Mr. Daniel, do you have a proposed order or are you going to submit one?
I do have a proposed order. I did email one to your system, but I also printed up 2 copies. So someone, did you see the one I emailed to you?
I did.
Okay. Let me approach it. You have a proposed order. Thank you.
Hand that back to you. Okay, sign the order. Anything further?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
What I say is to wait 6 weeks, run the eye chat again and make sure it came off, because they're so
Okay, looks like we have both counsel connected, so we'll go on the record now. In Patricia Cooper versus Beaver Creek Township, the Township Board and Kim Van Nuck. This is file number 2511863. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Mark Delden appearing on behalf of the plaintiff, Patricia Cooper.
Good afternoon, Your Honor. Charles Belgren on behalf of the defendants.
All right, thank you. This is the date and time set for plaintiff's motion for summary disposition. I did have a chance to review the plaintiff's motion and brief in support, the defendant's response, and then the reply that was filed by the plaintiffs, along with the file generally, the complaint, as well as all the attachments to the motions and briefs. So I'm pretty well versed in the facts. Plus, as counsel's aware, I previously considered a motion for a temporary restraining order. So I got an early look into the case through that. So now is the time for oral argument. Mr. Delden, anything that you wanted to present today in support of your position?
Certainly, Your Honor, and I will try to be brief. I understand the court has reviewed everything. There's no factual dispute that Patricia Cooper never committed a breach of peace at any public meeting. There's just simply no fact in dispute about that. The response tries to make her look like a troublemaker, and they go so as far as to misstate what Exhibit 4 says when they state that a Michigan State trooper had to inform her to leave Township Hall. That's not what Exhibit 4 says. I didn't address that in the reply because I didn't think it was a material fact, but it is an important fact. She was never asked to leave by a state trooper, and that's not what that exhibit says. The relief that Ms. Cooper's seeking is a declaration that the defendants violated the Open Meetings Act by denying her access to what is now added up to be 11 public meetings, and also an injunctive relief against an ongoing violation. Now, this past Friday, after the reply brief was submitted, a new fact has developed, Your Honor. A special meeting of the Beaver Creek Township Board was had, and they finally rescinded the resolution that permanently banned Patricia Cooper. Given briefing was closed, nobody was able to apprise the court of that. An injunction, nonetheless, is still necessary and it's still appropriate because the statute provides that it's to compel compliance or, which is a disjunctive, to enjoin further noncompliance. When this lawsuit was filed, there was an ongoing violation of the Open Meetings Act. This was not a situation such as in the Spicer versus Columbia Township Board of Trustees case where it was a one-time violation. In that case, the municipality had made an error in the posting of the list of public meetings. That's not what happened in this case. There was an ongoing violation. There is an ongoing violation. When we look at Supervisor Van Nuck, her intent is made clear. Even in Exhibit B, which was originally filed with the motion, her email, she was trespassed. When she showed up, I called the police. If only I had a little more patience, Your Honor, and I'd waited a day to file this motion for summary disposition, I could have attached that resolution. I did not know that just minutes before my process server was serving the township, that they would actually pass that resolution, something that in 18 years I've never seen. That resolution shows Supervisor Van Nuck acted intentionally. It sets forth the basis, and she moved it, she approved it, she voted for it. There's been no rebuttal evidence offered about Supervisor Van Nuck's intent. No admissible evidence, no affidavit, nothing to show that she didn't intend to violate Ms. Cooper's rights. Sometimes rights can be violated accidentally, but we don't have an affidavit that says otherwise. All we have is her email, the resolution, and Ms. Cooper's affidavit. And so in addition to the declaration that the Open Meetings Act was violated and that Supervisor Van Nuck acted intentionally, in addition to the injunctive relief, the declaration should also say that the trespass notice is invalidated, and based upon the finding that an injunction was necessary, or that Supervisor Van Nuck acted with intent, that mandates an award of actual attorney fees and costs. And unless the court has questions of me, that's all I would like to add.
No, my question, and you've already addressed it though, is because I did read that there was a potential for some change to occur at that May 13th meeting. So I was curious about that, but you've addressed that. So I don't at this time, Mr. Bogren, any argument you wanted to present?
Thank you, Your Honor. I will appreciate being up to date. There are a couple of things I just want to address brought up by opposing counsel. First, to reference your point, this was originally going to be a motion that was passed, I believe, on the 13th. Fortunately, the supervisor came down with COVID, so they had to push that off. And last Friday, there was a special meeting in which they passed a new resolution withdrawing the initial. So when we're speaking about this being an ongoing violation, that is not the case. There has been affirmative action taken to state that this is not, in fact, any longer in power in, Beaver Creek Township. Additionally, opposing counsel referenced the fact that there's been no showing here that this was inadvertent. First, we cite directly to the cases that say, excusing from liability those public officials who act in good faith but inadvertently or mistakenly violate the act. Opposing counsel is trying to shift the burden here on a motion for summary disposition onto the defendants here. It's not in our position to have to show that this was or wasn't taken. This is on the pleadings that were given. There's been no showing that she acted intentionally to violate the Open Meetings Act. Whether they acted intentionally, which is the focus of most of their briefing as far as passing this resolution, I think we can all agree clearly that was the case. But that doesn't mean that that was a knowing violation of the Open Meetings Act, and there has been no showing to support that claim. So not only is this not ongoing, but there's been nothing to support the fact that this was a purposeful violation of the Open Meetings Act. So based on those reasons, Your Honor, we'd ask that this not be granted.
All right, thank you. Mr. Belden, as the moving party, I'll give you the last word. Any argument in response?
I don't believe the law requires that public official knows that they're violating the Open Meetings Act. It just requires that they act with intent in the actions. And this was not negligence or inadvertence. It's not a situation where she accidentally locked the doors before the public meeting and Ms. Cooper couldn't get in. She issued a trespass notice. She sent Michigan State Police out to her house. This was intentional. Thank you, Your Honor.
Okay. All right. So again, I did review the written submissions prior to today. Counsel's arguments here on the record are consistent with their arguments in writing. The only thing that's really changed, as indicated by the parties, is there's now been a resolution lifting the previous resolution that had been made by the board excluding Ms. Cooper, but I don't find that that is really relevant to the court's consideration, although it is obviously a big change in the current circumstances. So the plaintiff is asking for a number of different types of relief here through its motion for her motion for summary disposition, which is brought pursuant to MCR 2.116C10. Both parties correctly cited the standard under that court rule for the court to grant a motion for summary disposition, and that is when viewing all the facts in a light most favorable to the non-moving party, there's no question of material facts such that the moving party is entitled to judgment as a matter of law. In this case, looking at the types of relief that are requested, the request for declaratory relief and injunctive relief, to me, really kind of go hand in hand in this case. And what the statute really provides for isn't really declaratory relief. It's to either stop the violation and or to enter an order to prevent that same type of violation from occurring in the future. In this case, I think the parties agree there really aren't any questions of fact about what took place, both in terms of leading up to Ms. Cooper's exclusion from those meetings and her exclusion itself, and that it was ultimately pursuant to a resolution that was passed by the entire board that was put forward by the supervisor, Ms. Van Nuck. So I do find there aren't really any questions of fact that would have to be resolved by the court here in order to determine whether and to what degree relief is appropriate. There's no question that the plaintiff was excluded from meetings. There's no question that that was the result of conduct that occurred outside of meetings. In other words, not conduct that occurred in the immediate presence of the board during a meeting that would be subject to the Open Meetings Act. And I also think it's clear that that was an improper act by the township that was not authorized by statute. So the court finds that, again, under a C10 standard, there's no question that Ms. Cooper is entitled to injunctive relief. Given the recent action of the board rescinding that resolution, the court finds that it would be prospective injunctive relief. In other words, the plaintiff's entitled to an order that she cannot be excluded unless she engages in conduct that would allow for it under the Open Meetings Act. So the court finds that she is entitled to an order enjoining the board from excluding her from future meetings as long as she's otherwise in compliance with the provisions of the Act. Under MCL 15.271 sub 4, where the court finds that injunctive relief is appropriate, the court does not have discretion. The court shall award costs and attorney fees associated with the plaintiff obtaining that relief. So the court is granting the motion pursuant to C10 for an order enjoining, again, the township from excluding Ms. Cooper from meetings as long as she's otherwise in compliance and doesn't violate the act herself by committing a breach of the peace during the meeting. And that she's entitled to costs and actual attorney fees in obtaining that relief. And Mr. Delden, I will ask you to submit a bill of costs to the court. And then the court will fashion an order awarding those costs and attorney fees. The second aspect of this, because the plaintiff's also seeking individual damages of $500 plus costs and attorney fees with regard to Ms. Van Nuck, the supervisor. And under the statute, the court would have to find that Ms. Van Nuck intentionally violated the Open Meetings Act in excluding Ms. Cooper. And in this case, I think it's really important to draw a distinction between what the intentional conduct was here, because clearly there was an intent to prevent Ms. Cooper from having access to that public facility or the meeting space or to be at the township hall. There's no question that the intent was to exclude her from that. And the court finds, based on what I view are uncontroverted facts, that Ms. Van Nuck sought a resolution based on the plaintiff's conduct, that there was a basis to exclude her from the premises. And that isn't just Ms. Van Nuck taking unilateral action. She presented that to the board, and the board agreed and passed a resolution essentially trespassing Ms. Cooper from that property. And I think it's a reasonable inference based on the allegations with regard to Ms. Cooper's conduct that that action was taken to protect the board and the public and prevent her from engaging what the board at least perceived to be harassing behavior. And so while that resolution had the effect of violating the Open Meetings Act by preventing Ms. Cooper from being on the property, I don't find that there's any proof that it was enacted with the intent to violate the act. And I think, again, there's a difference between an intent to exclude her from the property, which they were arguably justified in doing based on Ms. Cooper's conduct, an intent to violate the act. And I think in order for the court to find that they had an intent to violate the Open Meetings Act, they must have engaged in some type of conduct that thwarted the purposes of the act or was geared towards thwarting the purposes of the act. And that, as I've already indicated in my written opinion on the motion for a temporary restraining order, in excluding Ms. Cooper, while it may have been a violation of the act, it did not thwart the purposes of the act. The meetings were still open to the general public. All the other requirements of the Open Meetings Act were complied with. So it's clear to me, and it doesn't appear to be any question of fact, in my view, that the board wasn't intending to violate the act or prevent some kind of public access to the meetings. Again, that resolution was intended to exclude Ms. Cooper because of conduct that the board, again, at least viewed as harassing and overbearing conduct. And I think there's a difference there. So the court finds that there is not a basis to grant the plaintiff summary disposition as to her claim that Ms. Van Nuck should be individually liable for damages for violating the act, because the court finds it was not intentional. And I find that there's no question of fact that it was not intentional violation of the act itself. And therefore, the court finds that the defendants are entitled to summary disposition under 2.116 I2 with regard to the individual claim against Ms. Van Nuck. Finally, the plaintiff has also requested relief in that the trespass order be rescinded, obviously by resolution that's already been rescinded. Even if it had not been rescinded, in my view, that's a completely separate issue. Whether the board had grounds to trespass Ms. Cooper because of her conduct from the property generally outside of the Open Meetings Act, I think is a completely different issue. And certainly there's, I think, probably plenty of divergence of views as to what her conduct was and how that affected the board's functioning generally, and whether or not she should have been excluded from that property outside of public meetings. So even if they hadn't rescinded that resolution, the court finds that that relief would be beyond the scope of the plaintiff's complaint seeking relief under the Open Meetings Act. So to sum up, the court is granting the plaintiff's motion for summary disposition under C10 with regard to injunctive relief. The court is denying the plaintiff's motion under C10 regarding her individual claim against Ms. Van Nuck, and the court is granting summary disposition to the defendants under 2.116 I2 and dismissing plaintiff's claim against her. The court is dismissing plaintiff's claim with regard to the trespass order likewise. So Mr. Delden, if you would, I would request again that you would prepare an order that reflects the ruling of the court today, and either get a stipulation as to form from Mr. Bogren or submit that under the 7-day rule, along with your actual costs and bill of attorney fees. Don't enter an amount. The court will review the cost and attorney fees submitted and will enter an amount in the order.
And so, Your Honor, should my order have 2 blanks in it, or will the court order? Okay.
Yeah.
Thank you.
Yep. You just leave a couple blanks there. And then just indicate, because I think that this would resolve all the claims, if you can just indicate that closing language in the order as well, that resolves all pending claims and closes the case and is the final order.
Okay.
Mr. Bogren, any questions about that final
I believe so, Your Honor. Thank you.
Okay. All right. Thank you. That's all I have for today, and both counsel are free to disconnect at this time.
So, Your Honor, there was a pretrial conference scheduled as well, so I assume based on court's order, it's not going forward.
Correct. Yeah, I think this.
Okay.
This resolves it. So.
Thank you, Your Honor.
Okay. Thank you.
Thank you.
Okay. I'll be back at 4.
No, it's been actually probably half an hour.
Cases from our,
I don't know, there's a random. Okay, it looks like we have everybody connected. The person signed in under PMR. Ma'am, are you April White?
Yes, sir.
Okay, great. So we'll go on the record in White versus White. This is file number 2511858. Ms. White is present on her own behalf. And Ms. Robinson, you're representing Mr. White, is that correct?
Yes, Your Honor.
Okay, and Mr. White is also connected. We're on the record here today for purposes of a scheduling conference. Ms. White and Ms. Robinson, typically at this conference, the court tries to determine whether there are issues that will require mediation or eventual decision by the court, or whether the parties have been able to reach any kind of agreements on how to divide up assets and debts. So as the plaintiff, Ms. White, I'll ask you first. Have you had any discussions with Ms. Robinson or reached any agreements yet?
Never spoke to her.
Okay. All right. Ms. Robinson, can you tell me your side of how you want to proceed?
Yes, Your Honor. I believe we just have a very small amount of property to divide up. Actually, I believe there's some personal property to reclaim and a singular joint debt, from what I understand. So I think we can come to a quick resolution on this one. There's not a lot else to deal with in this matter.
Okay. So I'm going to I think for purposes of scheduling, I'm going to keep this open for discovery for 60 days. And Ms. White, discovery is just a process where each of you can send, formal inquiries to the other side about their position and any questions about assets or debts. And then I'm going to refer this to community mediation. And that's a process where both sides will meet with a neutral third party. They do mediation by Zoom like we're doing with the hearing today. Nobody's required to agree to anything, but they try to facilitate an agreement between everybody. And if you're able to reach an agreement, then we can finalize things. I'm going to have this referred to the community mediation process to occur within that 60 days. And then I'll set this for a status conference at that time. If the parties have been able to reach an agreement, then we can finalize the divorce at that hearing. And if not, then we can see where the sticking points are and then decide how to get those resolved and get things finalized. If you're all able to come to some type of agreement prior to that hearing in 60 days, Ms. White or Ms. Robinson, you're free to contact the court for a date and we can finalize things sooner than that. Ms. White, do you have any questions about that at all?
Just how to get a hold of Miss Brooks. I don't know what it is that is being asked. So just if you could send correspondence to me for what that is, and then I'd be happy to discuss it for sure.
Ms. White, is your phone number correct on our pleadings?
It should be 989-430-4057.
I will give you a call.
That'd be great.
Thank you.
Okay. All right. Ms. Robinson, anything else that I can address for your side today?
No, Your Honor.
Okay, so I'll send out an order that reflects the dates that we've discussed today. And then also with that, you'll both get a notice of the date and time of that hearing in about 60 days. And that's all I have. You're both, all parties are free to disconnect at this time.
Thank you.
Thank you.
That concludes the court's docket for today.